All right, guys, we are back. Make sure you have your cameras on, please. Nina, you had a question here. It says, so before we go into chapter 5, how are they elected? I mean, like do you have to live in a co-op as well as be elected? So the shareholders, they live in a co-op. And when we say we appoint shareholders, we appoint the board of directors, that means, like, let's say all of us own the co-op through our shares. We all are occupants of the building. But I'm going to appoint you, Nina, and Nidia and Reza to be the directors. You guys are the board of directors. So just like the homeowners association in a condo, right, Nina? In a co-op, the tenant shareholders become the board of directors. It's just that some of us are going to be appointed to carry that business. You got it? But yes, they're elected within. It's not outsiders. Could we outsource this to an outsider company? If we all agree to, yeah, for management of the building, yeah, we can. Absolutely. But we, the tenant shareholders, appoint whoever we want to be ahead of the corporation. Okay. Felix, make sure your camera is on. Elda, we got you on camera. All right, you were able to fix it. Good. Let's see. Amy, camera on. Olga, Lee, come back. Reza's in the corner. Make sure it's pointing at you. Romello, I charge double if there's more people attending class. Just saying. Okay. Brittany, I finally get like a half decent shot of you, because usually I just get half of your face or a quarter of your face, so it's good. Thank you. All right, if anybody's watching on YouTube, let me know you're there, and if you have any questions, drop them so I can address them. All right. And let's move forward. We're going to talk about encumbrances and liens. Now, in this one, I already have a few things written down, and where it says encumbrance, I have written cloud or restriction on title. So I'm going to zoom in. In front of encumbrance, I have cloud or restriction on title. Cloud or restriction on title. Okay, very important. Encumbrance, cloud or restriction on title. Where it says easements, an easement is a right to use someone else's property. Easement is a right to use. Where it says encroachments, and we're going to go over all this in a little bit. Where it says encroachments, it's illegal extension over somebody else's property. Remember, all of these are on somebody else's property. Okay, not on our property, somebody else's property. Okay, Aisha, how are you? Watching on YouTube, cool. If you have questions, let me know. All right, Josue, 74 on exam. State exam, you're saying? 74? So you needed 3 more questions to pass. Not bad, not bad. You're close, very close. I can help you by telling you to try my practice exam. I can help you by telling you to rewatch these things, or by asking specific questions. And I can also invite you to take the our practice exam. So let me know. Any questions you have, just reach out to me. Or drop the questions here in the YouTube chat, and I'll address, because it will help the students as well. All right, guys. So the next one was license. A license is permission or privilege. Permission or privilege. Hey, Jose, just one question. Did you take the exam today? Let me know if you took the exam today, because if you did, try to schedule ASAP, because somebody with a 74, you only need 3 questions to pass. That means you got it, and you should remember most of those questions. So go and take it again right away. It's very, very important. Okay, you gotta do it back to back. The longer you wait, the worse it is. So do back to back. If you're that close to passing, don't wait. Don't wait too long. Okay. All right. So back to this deed restrictions. They're placed by the seller usually. Placed by the seller. So these are private restrictions. Liens mean money. So if you don't pay the money, if it's unpaid, they can resort to foreclosure. All right. So let's go over these in detail. Okay. All right, Jose, reach out to me on WhatsApp, 908-418-8325, and we'll figure it out. But if you have any questions now as we go, do ask questions, okay? So right here, we're going to start with encumbrances. And an encumbrance, I told you guys, is a cloud. Why do we call it a cloud? Let's think about this real quick. The weather changed. Because the weather changed, right, drastically, right? We went from 70 degrees to 40 degrees in 2 days, right? Crazy. But because the weather changed, do we have the same desire to be outside? Can we do everything that we want outside? We can't. So the weather limits us. So when we're talking about a cloud, we're talking about a limitation on the property. Right? If it was summertime, well, if it's not too hot, obviously. If it's summertime or spring, what can we do? We can pretty much do everything. It's sunny outside. You can go to the park. Everything's beautiful, and you can do whatever you want. You're full of energy. Come wintertime, you start dying down a little bit because you're limited. You're indoors, pretty much. All right. So there's a limitation. Encumbrance is a cloud or limitation on title. Encumbrance is a cloud or limitation on title. Remember that. Okay? On title or on the property. So again, cloud limits. Okay? Limits, cloud. Very important you understand these words. Cloud, limitation. All right? Think about it this way. Can I sell the property? Can I sell the property with a mortgage on it? Most likely not. Most mortgages say if you're selling, you have to pay me off and let the buyer, right? Let the buyer get their own mortgage. Most lenders, that's what they put as a restriction on the mortgage. Okay? We're going to talk about it at a later time, but that's called a due on sale clause. Hey, the whole balance of this bill or mortgage is due at the time of sale. Okay? So it limits me because I cannot sell tomorrow if I don't have enough money, right? In fact, depending on the situation, depending on how we are right now in the economy, I might have to pay the bank in order to be able to sell my house, right? So this happened a few years ago where we were underwater. What does that mean? You owed more than what the property was worth. So could you sell? Very difficult. You either get the bank to approve a short sale or you have to pay to sell. So very, very difficult. Again, encumbrance is a limitation. So anything that limits the property's value or the owner's freehold interest is technically an encumbrance. Now, an encumbrance, this word is very important because even though it limits the property, it does not include the right of possession. An encumbrance is an interest or a benefit or a claim. If you guys remember that from estates and interests, right? It's an interest, a benefit, or a claim that somebody can have on your property. They don't own the property, so they cannot sell the property. We go back to the mortgages. when they foreclose, if they foreclose because we don't pay the bill, can the bank sell our property? In the foreclosure, can the bank sell our property? Let me know your thoughts, guys. In the foreclosure, can the bank sell our property? Go to the chat. All right, there's a few missing, but okay, we're going to go with this. There's only one correct answer so far. One correct answer. No. The bank cannot sell the property. The bank has to ask the court through the foreclosure proceeding. You have to ask the court for the property to be sold. So who orders the sale? The judge. Who sells the property? The sheriff. The bank cannot sell your property. They have an interest, benefit, or claim in the property. If unpaid, they take you to court to claim that interest. You guys got it? So we're going to go over foreclosure in a little bit, but I want you to understand the difference between what an encumbrance is and what title is. I own the property. I can sell the property. That's voluntary. But I can also be forced to sell the property through foreclosure. So the judge forces the sale, never the lender. Okay? My point was, an encumbrance does not include right of possession and is therefore lesser interest than the owner's freehold interest. Okay? So there's other states where it operates a little bit different, but it's still based on an agreement. And it's not the bank that sells, it's a third party that will sell the property, just like a sheriff. Okay? So, an encumbrance can lead, right? An encumbrance can lead to the owner's loss of ownership of the property. So somebody's going to have to force that sale, okay? But they cannot sell it. They have to force it through an auction or through a sheriff's sale. But either way, it's third parties. It's never the one with the encumbrance. Okay? In the rawest scenario, the very stupid scenario, it's very simple. You owe me money. Can I go into your house and take money from you? Can I go beat you up old school mob style, break every single bone you got just to get my money? I cannot. What do I have to do? I have to go to court and sue you in small claims court for money. So that's the same thing. I cannot just take your house away or sell your house. I have to go through court. Okay? Sorry about the stupid comparison, but I think it was a good way to explain. All right. So, general types of encumbrance. We have restrictions on the owner's use by others' rights to use. Easements, encroachments, license, and deed restrictions. We'll go over that in a second. Restrictions on ownership or value and transfer are liens and deed conditions. So these can lead to transfer of the property. So we're going to start with easements. Now, easements. Earlier, you guys wrote down that easement was the right to use somebody else's property. Easement is the right to use someone else's property, right? So there's different types of easements. There's easement appurtenant. There's easement in gross, right? These are the two different types of easements. And within these easements, there's more. But easement appurtenant, guys, easement appurtenant means we have adjacent parcels. Appurtenant means we have adjacent parcels, meaning they're attached. Like a shared driveway. Your neighbor has the right to use your half of the driveway. You have the right to use their half of the driveway. That's an easement appurtenant because the properties are attached, adjacent properties, okay? Side by side, attached. An easement in gross is the simple right to use someone else's property, like utility companies. They don't have their property attached to yours, but for them to maintain the water, the sewer mains, the light poles, and so on, right? They might have to enter your property to work on them, and they have the right to do so. It's called easement in gross. It's the simple right to use someone else's property. You got it? These are the two basic easements, either appurtenant because it's attached, or in gross, it's someone else's property, not attached to mine, but I still have the right to use it for whatever purpose. Okay? So, again, I have this highlighted. Easement is an interest in real property that gives the holder the right to use portions of the legal owner's real property by defined way. Now, easement rights may apply to the property surface, subsurface, airspace, but the affected area must be defined. The receiver of the easement right is the benefited party, and the giver of the easement right is the burden party. All right, so I have a better way to define this later on, so don't worry so much about it. There's a benefit and there's a burden. Okay? I'm benefiting from walking into your property, and the burden is the fact that you have to allow me. So you're burdened by having that pathway for me, as an example. Essential characteristics of easements include the following. An easement must involve the owner of the land over which the easement runs and another non-owning party. One cannot own an easement over one's own property. So think about it. I have two properties side by side. I own property A, I own property B. Do I need to allow myself over my own property? Right? I get to the edge right there and I go like, can I go in? Can I go in? Hold on, let me call myself. Let me talk to myself. Look at the mirror. Can I go in? Right? No, we don't do that. So for an easement or a right to use someone else's property to exist, there must be two separate owners. Okay? Two separate owners. Very, very important here. Okay? There's two basic types of easement. They're appurtenant or in gross. We already talked about it. Appurtenant means they're adjoining property owned by another party. And the property enjoying the usage right is called the dominant tenement or dominant party, right, or estate. And the property containing the physical easement itself is the servient tenement. And it must serve the easement use. What I did here, to make it easier for you guys, when you see the word dominant, we're talking about the guest. The servient, we're talking about the host. And I want you to think about it this way. If you invite me over to your house for an event, party, whatever, am I expected to serve you or are you expected to serve me? How do parties usually work, right? If you are the host, you usually serve the guest, right? So who dominates in this transaction? Like, I want some of that pizza. I want some of that wine. I want some of that beer. You're serving and I'm benefiting from it. Does that make sense? So I dominate. Oh, I need to use the bathroom. What are you going to tell me? Go 3 blocks up and there's a gas station there? Right? You're not going to do that. Most likely you allow me because you are hosting. You are serving. So if going back to the shared driveway, right? The shared driveway as an example, I'm using half of your property. I'm dominating your half. You dominate on my half. You are the servient. You have to serve me your half of the property, right? While I serve you my half of the property. That's what happens with shared driveways. Another example, we're gonna have an image right here. Another example is this. See, dominant, lot 1 has no way to get to the public road. So lot 1 has to go through lot 2 all the way to the public road. So lot 2 is serving the access, the pathway, and saying, hey, all right, come on in. Pass through my property, get to the public road. You guys understand? Otherwise, this person is landlocked, cannot go anywhere. So they have what's called an easement by necessity. They have to go through someone else's property in order to get to the public road. All right? So that's exactly what happened here. They need to go, this is their property limit, and now they're onto A's property, right through to the public road. So they benefit, they dominate, and lot A serves, is the host of the benefit. You guys good with this? Okay, let me know if there's any questions before I move forward. All right, no questions? All right, cool. So let me go back up. I already explained this, but I highlighted in green in the book, so make sure you remember. Appurtenant means attached to. So again, easement appurtenant is two properties attached. All right. Right after that, we have easement by necessity. I also already explained when lot 1 needed to go through lot 2 to get to the public road. They were landlocked. They had a need to go through somebody else's property. Okay? So again, landlocked were without legal access to public roads. That's an easement by necessity. Nina is asking, are easements located in gated communities only? Nope. Could be, like I said, it could be a shared driveway, as an example. So if you are on the 123 Main Street in Woodbridge, let's say, right, and there's a little driveway between your property and somebody else's property, that's an easement. We share the driveway. That's an easement. Right? You have utilities in your property, don't you? That's an easement. The city has an easement on your property. They have the right to use your property for distribution of water and sewer mains and maintenance. Utility companies, they have an easement in gross. They have the right to use your property to distribute electricity, to distribute cable, right? The cable service. You guys know sometimes it runs from your property to another property, right? So it's attached. It's a simple right. Easements happen everywhere. In fact, we have something called party wall easement. What is a party wall easement? A party wall is a wall that separates the parties. Meaning, I'm right here, and on the other side of this wall, there's somebody else, right? As an example. This is my property, that is their property, and we share a common wall. So we find this in townhomes, in condos, right? In multi-unit building condos. These are duplexes. If they share a wall that separates the ownership from one to the other, this is called party wall easement. But easement means right to use someone else's property. Guys, how am I using their property, or how are they using my property? Anybody? How do they have the right to use my property and I have the right to use their property? How does that work? What's your opinion on that? Anybody? What is your opinion? What do you think the party wall is for? What rights do I have on their property, or what right do they have on my property? Nobody? To please both sides. Aw, such a pleaser. Because like a co-op, you own from the wall in. Okay. Benjamin, privacy. All right, cool. Anybody else? All right, let me ask you something, guys. Let me ask you. Property division. Well, yeah, to separate the property, got it. But you have to think about the shared driveway. It's the same concept. I have a right on your half, you have a right on my half of the driveway that we share. I have a right on the other side of this wall, and they have a right on this side of this wall. You know why? Because I have to maintain this. If I don't maintain my side, it could damage their interest in the property. So now it damages their property. If they don't maintain their property, it damages my property. You guys understand? So the party wall easement is a right that I have on the other party's property for maintenance and repair of their wall for support of my wall. Just like a shared driveway. They have to maintain their side because I still go through. We have, like Vanessa wrote, we have a common interest. So both parties need to maintain that common interest. You guys good? Thumbs up? Great. Hey, Josue, if you're watching, if you're listening still, I got somebody else just text me saying that they got 74 as well by 3 points, 3 questions. All right? Not as bad as one question. Imagine not passing by one. That's the worst thing. All right? But it means you're one step closer. One step closer. So now is the time, again, as I said earlier, is that back-to-back thing. As soon as you pass one, as soon as you get a score like that, anything above 70, don't stop. Go right at it again. Okay, very important. Try to remember as much as you can, guys. This is for everybody, not just for Josue here. For everyone. Always try to remember what happened in the state exam. Like what questions, what you got stuck on, right? What were you wondering? As soon as you get out, you probably won't remember a thing, but once you get home, grab the book, review it real quick, and try to remember, oh, there was a question about this. Write it down. And then ask me questions. Bruno, this was the question. What do you think? Most likely, I have a very similar question. So I'll be able to give an idea of what the potential question was and what the potential answer was. Okay? Josue, just so you know, you can do it online now. As of yesterday, you don't have to go all the way to New York. You can do it online. Okay? I'll have a video out real soon on how to schedule those, but it's actually very easy. All right, back to this. Easement in gross. So I told you guys, easement in gross is using somebody else's property, but does not have to be attached. Like utility companies. Their property is not attached to yours, but they have the right to use and maintain your property. Okay? So there are no dominants or serving the states in an easement in gross. They just have a simple right to use the property. And here you go. Easement in gross. These right here, these are utility, these poles. Dots right here. It's a commercial easement in gross. Okay? Utility companies. You cannot take it now because you're still in class, but yeah. As of yesterday at 6 o'clock in the morning, they enabled for you to be able to take the state exam online, both for real estate and for insurance, which is great because I teach both, and it's going to be awesome. For me, it's going to be awesome. For my students, it will be awesomer because you don't waste time in traffic, you don't get stressed in traffic, no road rage. You can be nice, cool, relaxed in the comfort of your home. Okay? Just make sure you have no distractions. lock your kids and spouses in a cage, and go test. Very important. Okay. Next. The cage was a joke. Putting it out there for anybody that's sensitive about the whole cage thing. Romelo's like, yeah, I would put him in the cage. You're talking about the spouse or the kid? The baby. All right. Oh, that's bad. That's bad. That's bad. The spouse, I understand. All right. Easement creation. This is very simple. You can create it voluntarily where we both agree, obviously. And there's the easement by necessity where I need to go through. So it's forced. Okay. So voluntarily is we both agree. By necessity, you are being forced because there's no other way for me to get to the public road. But there's another one. This other one that I wrote here, abandonment claim, is called easement by prescription. What does that mean? Think about the example I always give. It's the same example every time. Think about a $100 bill that you just found on the floor. What would you do, guys? Who would? Who would? And be honest, okay? You don't have to go goody two-shoes on me right now. Be honest. Who would start yelling, who lost $100? Let me know in the chat. Who would start waving the $100 and be like, hey, did anybody lose $100? Go ahead. Tell me, who would? Write it down. Then it's that bad? You don't want to be that honest? You're just shaking your heads, but you can't write down, no, I wouldn't. All right? It's okay. It's only on YouTube Live. Everybody gets to see your name or you get to keep other people's money. Like, no shame to it. I would. I would keep the money. Felix says depends. Nina says I would leave it on the floor. Oh, you'll do like me. You just put your foot on top. Leave it on the floor, put your foot on top. Wait to see if anybody comes. Josue wrote, look both ways before picking it up. There you go. Teresa says, it's mine now. Benjamin says, not me. All right, you know why? Because as soon as you raise your hand and say, hey, did anybody lose $100? It's not like it has your name on it, right? So anybody can claim it. The moment you say, I lost did anybody lose $100? Anybody can come up and say, yeah, those are mine. In fact, if you look at the serial number is SA12345XE. Right? Who's going to come and say that? Who counts their money and looks at the serial number, takes pictures, and says that's mine? Nobody. So anybody can claim it. Now, right here, this is important. What Elda just wrote, translating, she'll wait for somebody, right? So here's the thing. Every time you see something on the floor, there's something called like the lost and found. There's a procedure to lost and found, right? And pretty much you wait a certain period of time, and if nobody claims it, if nobody claims the property, whether it's $100 or you found the cell phone or you found the computer or you found the car with the keys inside, I mean, whatever way you guys find stuff, right? Either way, it's called abandonment claim. They clearly abandoned the property. If it's abandoned, right, I can now claim it. And that's what we're talking about for real estate. It says right here, if someone uses another property as an easement without permission, right, the $100 is not yours, you're using it, without permission for a statutory period of time, so you have to wait a certain period of time, and under certain conditions, a court order may give the user of the easement right by prescription. This is regardless of the owner's desires. Zanai is so sweet. Zanai just wrote, if I find it on the street, it's mine. If I find it in the supermarket, I'll take it to customer service. Not bad. Not bad. Let me know which supermarket you go to so I can go work there at customer service. Because I'm pretty sure they're the ones keeping that money. Anyway. But that was good. I mean, I have to respect that one. That one's actually good. If it's in the supermarket, probably somebody's going to be looking around. Look at the wallet. You know, they lost their money. Anyway, so, and I'm just joking, but this is the society that we're in, right? You find something and you'll take it right away without questioning anymore, right? Some people would even look both ways, like Josue said. Others just start running, like the cops are chasing them. $100. All right. So abandonment claim, very important. For a prescriptive period, for a prescriptive easement order to be granted, the following circumstances must be true. Very, very important. Adverse and hostile use. That means the use has been occurring without permission or license. You're using the property without their authorization. Okay? It's not breaking and entering. I'll explain that in a second. It's not breaking and entering, but you're using the property without their permission. Open and notorious use. The owner knows or is presumed to have known the use, meaning you're not hiding. Everybody can see it. If he did not see it, right, the neighbors saw it. If nobody complained about it, hey, I did my part. I was not hiding. Okay? And it must be a continuous use. That means uninterrupted period of time for you to be able to claim it. Every state has a different period of time or prescriptive period. In the state of New Jersey, for instance, guys, we have a 20-year waiting period or 30-year waiting period, depending on the circumstances. And you have to use the property for 30 years. If nobody shows up, go to the judge. I mean, if you don't show up after 30 years to see your own property, what does that say? Do you care about this property? No, after 20 years, literally, you abandon the property. That's what it is. In Florida is 6 years. In Texas is 5 years, and then, I mean, it could be 15 years, but depending on how you use the property, it could be a shorter period of time. So every state has their own rules. Every country has this right to claim property. Okay? And you have to think about it this way. Imagine back in the day when we had the wars, right? The people were going at seas for years, maybe not coming back, right? There's a piece of land right here, and this person has not come back in 30 years, 40 years. They sailed away and never came back. What are we going to do? Just leave the property there? No. The government doesn't want the property. They don't want to hold real estate. They want to make money from real estate, the taxes. So what can we do? We identify the abandoned property. We jump in. We use the property. Take over. That's what it is. Abandoned claim. All right? Nina, why is New Jersey time limit so long? Because they want to make sure that people clearly abandon the property. All right? Because look, my first time when I came to the United States in 2001, I stayed here 6 years without going to Portugal. So imagine that was Florida. I would have lost my property already. You see what I'm saying? So in Portugal, this law is 25 years. You have to wait 25 years before you can take over abandoned property. 25 years using. So again, it's to protect the homeowner. Okay? But I'll show you later on, I'll show you a way to do this in 2 years. Okay? So if you want to legally steal other people's property, there's the 20-year waiting period. It's called adverse possession. Okay? Or I'll show you the 2-year waiting period. Just make sure it's abandoned property. Very, very important. Okay. And now some of you are like fearing for your properties, huh? What does Bruno know? Can I lose my property in 2 years? To Bruno? Yeah, you can. If you fail to do one thing, I can take your property. Legally, lawfully. No jail time for me. Yep. All right. Eminent domain. So the government can also take the property away from you. Not only can you have an easement by prescription, which is a private entity taking over your property, the government can exercise what's called eminent domain. And we have a chapter that talks about the powers of the government as well. But government entities can create easements through the exercise of eminent domain, where they condemn a property, a portion of the property, and cause it to be sold for a greater good. Okay? So I can go to you and say, hey, Nidia, I need your property. I need your property, and I need, no, sorry, you don't have an option. You can shake your head. You don't have much of an option. Let's see, I have Nidia, I have Elda, I have Romello, Brittany. So I need your 4 properties. I need to knock them down to build a new school for the community, as an example. So I'm going to take your property because it's for the greater good, but I have to give you fair compensation. I'm not just taking it away. I'm going to give you money for it. You just might not have profit. It might not be the amount of money that you want or you'd like to have, but I'm taking it. That's the power that the government has of acquiring privately owned property. All right. Encroachments. So where it says encroachments, I told you guys that this was an illegal extension over somebody else's property, encroaching, right? So it's the unauthorized physical intrusion of one's real property into another. Unauthorized physical intrusion of one's property into another. Okay? So imagine this. I have a fence right here, and this fence separates my property from your property. Right? That's how fences work. But in case you guys don't know, usually one fence belongs to me and the other fence on the other side belongs to the neighbor. Unless you install your own fence around, but one belongs to you and the other one belongs to me. Because there's property line, and then there has to be a space between property line and fence. Okay, the fence cannot be right on the property line. So let's say I'm going to replace this fence because it's about time. It's that metal mesh one that nobody likes, and I want that really tall vinyl white fence, right? So what am I going to do? I'm going to take this one out, and I'm going to install a new one. But I decided to install a new one right here. So I moved 1 foot over. Okay? Here's the thing. I didn't move just 1 foot over. I moved 1 foot over times 100 feet, which is the length of my property. So I have 100 square feet that I just gained by moving over. If you guys don't complain, if you don't complain about that fence in the next 20 years in New Jersey, I can claim easement by prescription. So now I can go to a judge and say, hey, can you cut that piece off of my neighbor's property and give it to mine? Literally, that's how it works. So somebody could be using your property over time, right? Using your property, unauthorized use of your property, and after 20 years, they can claim easement by prescription. Crazy, right? Yeah. All right. Next one we have is license. Now, license, I have a simple question for you guys. Ready? Who has a driver's license? Raise your hand if you got a driver's license. All right, cool. People on YouTube are raising their hand, but I can't see them. So, so if you got a driver's license, who does that license belong to? Let me know in the chat. Who does that license belong to? You have a driver's license. Who does the license belong to? Licensee. Felix says me. Ramel says me. Alondra says me. Ah, Benjamin. Amy? No. Benjamin just answered correctly, just like Josue on YouTube. The state of New Jersey, the state of New York. It's a New Jersey's driver's license. A New York driver's license, a PA driver's license. It clearly says it's theirs. And they give you the license, right? But can they revoke the license? So how was it yours? If it could be revoked, if it could be taken away from you, how was it yours? Are you guys understanding this? You got it? So very, very important. Very, very important. A license is revocable at any time. So the point here was, I might allow you to park on my driveway. I might allow you to park on my driveway. But 5 minutes later, I can say, hey, sorry, come back. Take your car. You guys understand? A license is a permission or a privilege that's given to you, right? And it could be revoked at any time. So it's not an easement, meaning it doesn't give you a right. Doesn't give you a right to it. It allows you temporarily or gives you some type of interest in it, but not a right. Very simple. You need to know this difference. Nina says that's why you need to have a new license when you move. Yeah. Pretty much what they want is you registered within the state. That's all it is. But yeah, it's they give you that license. Driving is driving. We go across the states. We can go to Mexico with our driver's license. Right? Driving is driving. You can go to Portugal. You can go to Hawaii. You can go to China. A driver license is a driver license, right? It just says that you supposedly know how to drive. Supposedly. That's all. So the state boundary, the fact that you have to register in another state is because now you're a resident of that state. So anyway, it's a way to get you registered. That's all it is. All right, so like I said, I can grant you a right to, a license to do something on my property, but I can remove it later. Deed restrictions. When it comes to deed restrictions, here's what you need to remember. Deed restrictions are private restrictions. Private restrictions. It's not the government putting the restriction on you. It's the seller usually putting that restriction on you. So I'm selling to you. If you guys remember this, I sell to you as long as, I think I said when Romello, as long as Romello is alive, right? Remember that one? So there's a restriction. The property is his or somebody else's as long as he's alive, right? So that's the limitation. It's a private limitation. It's going to be on the deed itself, on the deed of transfer. Okay, we already talked about this the other day. Move. Liens. Liens. What is a lien? Earlier I told you guys lien means money, right? Dollar signs. So a lien technically is a financial claim. That means you have unpaid money. The property becomes a security for the debt. So if they put a lien on your car, it's because you have a financing that you need to pay, right? And they can come take the property away if you don't pay. If they put a lien on your house, they call it a mortgage, right? Is because you promised to pay $300,000 to buy the house. If you fail to pay, they exercise what's the mortgage and the right to foreclose. That's all it is. Okay, so every time you see the word lien, think of money, think of financial claim. So in the question, you could say, the owner of the property has failed to pay or something like that. It already talks about paying, it talks about money. And the creditor has the right to foreclose. This is an example of, and then it gives you 4 different options. Because it's a payment that must have been made, and he has the right to foreclose on the property, it's an example of a lien. A lien is attached to the property. Okay? I can owe you money, but it's not attached to the property, so therefore it's not a lien. You got it? Okay, so think about a lien like leaning onto the property. It's attached to the property. If you don't pay, there goes the property. Okay? And Zenaida just wrote, attached to the property, not to the property owner. 100%. Attached to the property, not to the property owner. Because it's 2 separate documents. There's the mortgage and there's the promissory note. The mortgage is the lien attached to the property, while the promissory note is the personal obligation to pay. So, 2 separate things. And we'll have another chapter just for that. All right, I already talked about this. They do not convey ownership, right? You have to foreclose first. It attaches to the property, so we cover this. A property may have multiple liens. We got that. A lien terminates on payment of debt. So if you paid in full, then the lien is released. So no longer attached to the property. Very good. And then we have voluntary and involuntary liens. Now, let's look at the word voluntary and the word involuntary. Forget real estate, guys, for a second, for 1 second. Forget real estate. What does voluntary mean? Let me know in the chat. What does voluntary mean? Forget real estate. What is something that's voluntary? At your will, freely given. Absolutely. You want to. It's voluntary. Right? Like being here, it's voluntary. Nobody's being forced, right? Anybody being forced? Raise your hand. We'll call the cops. No? Okay, good. So, voluntary, doing something willingly. Very good. What about involuntary? Involuntary. Forced. Absolutely. Obligated. Absolutely. So here's the thing, guys. Very, very important you guys understand this. There's two different types of liens. Voluntary and involuntary. A voluntary lien is money that you asked for, and therefore they put it against the property. So like a mortgage. You asked for the mortgage money, right, to be able to buy the house. Correct? So it's a voluntary lien. You borrowed money. The involuntary lien is you being forced to get it on your property, like taxes. Whoever asked for taxes, raise your hand if you ever asked, hey, tax me. Tax me. Did anybody ever do that? No, so it's forced on you. Got it? Voluntary, you ask for that money and you're paying for it. Involuntary, nobody asked for it, but you still got to pay it. Okay? So voluntary, involuntary. And then we also have general and specific liens. Now, a general lien is one that is placed against any and all real and personal property owned by a particular debtor. So a general lien attaches to your house, it attaches to your car, it attaches to your banking account, it attaches to your salary, it attaches to your taxes, to your driver's license, as examples. Like if you don't pay the IRS, or if you don't pay child support. These are the two most common liens, general liens in the United States. Okay, so IRS or child support. They attach against everything you have, even your passport. If you don't pay these, they'll suspend your passport or revoke your passport temporarily. You guys got it? So these are general, affect everything. As far as single or specific liens, right? Specific liens, they attach to that one property. So for instance, if you borrowed money to buy a car and you stop paying, can they come take your house away? No, they repo the car. If you ask for a mortgage loan to buy the house and you stop paying the mortgage, can they take your car? No, they can take the house. These are specific liens. It attaches to one single item. General liens affect everything you have. Specific liens affect that one thing that it was attached to. Okay? Let me know if you guys are good. Thumbs up. All right, this is easy peasy, right? No questions here? Great. So now it brings us to superior and inferior liens. Superior liens, or prior liens, or priority liens, are always real estate tax, special assessments, and inheritance tax. Every other type of lien is called a junior or inferior lien. Okay? So taxes are always superior. What does this mean? It means at the event of foreclosure, who gets paid first? And the answer is taxes, real estate taxes are paid first. Okay? You guys got it? Income tax is an inferior lien when it comes to the property. So if you don't pay the IRS, they are not superior. Real estate tax gets paid first, then everything else. And there's an order to this. Okay? So it says right here, with the superior and inferior categories, ranking a lien priority determines the order of the lien claims on the security underlying the debt. The highest ranking lien is the first to receive proceeds from the foreclosed and liquidated security, and the lien with the lowest priority is the last. What you need to remember is this. First thing, is it superior or is it junior? If it's taxes, superior, they're always first. Junior liens are based on date of recording. Date of recording. So this means first in time, first in line. Okay? First in time, first in line. So taxes are always paid first, and then everything else is based on when did you record your lien. So if I recorded a mortgage in 1995, and then the second mortgage was recorded in 1997, which one has priority? Well, the 1995, because they recorded first. So in the event of foreclosure, they get paid first. Okay? First in time, first in line. But taxes, no matter what, are before any of the junior liens. So first in time, first in line, with the exception of taxes. Okay? Taxes are always, always before any of these. Okay? So I have this right here. Superior liens in rank order. We have real estate or estate tax. Income tax does not fall here. So real estate or estate tax. These are first, no matter what. And then junior liens are based on date of recording. So there's no superiority here. If the federal income tax lien came 10 years later, then they're junior to the junior. So they're like a third or fourth lien. Okay? Zillian, you cannot be taking pictures like that. Nobody said you could be taking pictures of the screen. I'm just kidding. So like she got paler than me. Don't worry about it. I'm just kidding. You can always screenshot. I don't care. Can't believe you guys. I know it's the second day, but still falling for it. All right. I already explained this. All superior liens take precedence over all junior liens, regardless of recording date. Everything else is based on date of recording. Right here in green is first in time, first in line as well. And then there's this one, mechanics lien. Now, when we're talking about mechanics lien, we're talking about construction work that was done on your property, right? And you did not pay. Construction work that was done on your property and you did not pay. Are you guys with me? Because I see two people frozen. I want to make sure you're with me. Shake your head if you're with me. Cool. Can I repeat what? You were taking a picture and you did not hear? You weren't writing it down. What do you want me to repeat? Oh, mechanic. Okay, I will right now. So mechanics lien or construction lien is the same. Mechanic lien or construction lien. They're an exception to the recording rule. So the recording rule is first in time, first in line, right? That's the recording rule. Construction liens, they're operated a little bit different. Because a construction lien or mechanic lien is you did some work, somebody did work on your property, and you did not pay them. So for them to make it a lien, they have to sue you first, right? And a lawsuit takes years. It could be 3 years, 4 years, 5 years before there's a decision, right? So think about it. I got, and the example is, there's a similar example here, but I got a property in 1998. I got a property in 1998, and that property came with a $300,000 mortgage. Okay, that's how much it cost for me to purchase. Then in 2000, I did some work to the property, $50,000 worth of work. In 2001 or 2002, the market was going up. So I was able to get a second mortgage later on for $150,000. Now you guys understand this? So I had $300,000, $50,000 worth of work to the property, and then a second mortgage of $150,000. Now the $50,000 work that was done, it's not recorded against the property. You got it? It's just work that was done. It's not recorded anywhere. Are you guys with me so far? Great. So it's not recorded anywhere. So if we just talked about it, who would have priority here? Well, it would be the 1998 mortgage that I got, and then the 2001 mortgage that I got. So that would be the priority. And the construction would have no priority because it was just work that was done. The thing is that there's a lawsuit pending. And once that lawsuit is decided and the judge says, well, you owe money to ABC Construction. So once the judge says you owe money, once he or she makes a decision, the construction company can now go with that document to public records and say, I have a judgment against this property. You guys understand so far? Okay. Because the judgment is based on work done between one mortgage and another, the judgment came years later. But the work began or ended or material was first delivered before that second mortgage. So mechanics lien are the only ones that are retroactive. So they will fall into that time slot. They're retroactive to when the work began. I think I have example here. Thought I had it. Nope, might have deleted. All right, so we'll make a new one. So what we're saying here is I got a mortgage 1998 for $300,000. This is what you see on public records. And then in the year, so not recorded, this is not recorded yet. In the year 2000, I did construction. All right, so I used ABC Construction to do some work, and that work was $50,000. But I did not pay. In the year 2001, I had a second mortgage. I added because the market was going up, so I got a second mortgage of $150,000. Right? Good so far? So this is in public records. Everybody can see, right? and this one is not recorded. It was just work that was done at the time. So what we're saying now is because this was unpaid, ABC Construction took us to court. And the judgment, so the decision, came in 2003. There was a judgment in 2003 that says you owe money to ABC Construction. Good so far? It's still not recorded. So ABC Construction now has this judgment in 2003, and they take it to public records and record it. $50,000 are owed to the construction company. Okay? So on this side, everything happened outside of public records. It was a lawsuit. So unpaid bill, right? And then the lawsuit, and then the decision, the judgment. Okay? Now, if we go through foreclosure right now, I'm not paying the mortgage, one of these mortgages, and I go through foreclosure. Who gets paid first? Let me know. Who gets paid first in this scenario? Let me know in the chat. Who gets paid first? We are foreclosing. Who gets paid first? 1998? 1998, first mortgage. Repeat the question. I was saying if we get foreclosed, foreclosure is based on public records. So who gets paid first? If we get foreclosed based on this order, who gets paid first? All right. So Zenaida was the first one to give me the right answer, and then Teresa and Olga gave me the answer. Who gets paid first? Taxes get paid first, no matter what. There's always an open tax bill that needs to get paid. Always. So taxes are the superior lien. They have to be paid at foreclosure. Taxes. So now, who gets paid after? Okay. Let me just make this clearer here. Who gets paid after taxes? Anybody? Who gets paid after the taxes? That's right, 1998. So after the taxes, number 2 gets paid is 1998, so $300,000. If there's money left in the foreclosure, right, in the auction, then a third party will get paid. Who gets paid after the 1998 mortgage? $2,001? Did you guys forget that there was work done in 2000? And that's the reason why we're able to get this 2001 mortgage? That's the thing about construction or mechanics liens. They are retroactive. So that means that this right here, even though it was recorded after, it was based on work that was done before. So it takes priority over liens that came after the work was done. So this is number 3. And then this one would be number 4, if there's enough money. All right? So mechanics lien or construction liens, they're retroactive. They're the only ones that can bounce back to a previous date. because the lawsuit was based on work that I did before you were able to get the second mortgage. You were able to get more money because of my work. That's pretty much what we're saying. Okay? Question? Nope. All right. So what? Hold on, Felix. Is that a question or that's a slash? Who are you slashing, man? No, I got you. I knew it was a question. I just wanted to wondering where you were doing. $1998 is the first mortgage. So what is your question? That's why they got paid first. After taxes. Okay? After taxes, they got paid first. Very, very important. Okay? All right. All right, we already talked about superior liens as being real estate tax. But there's one more called special assessment lien. And special assessments are for public improvements, municipal improvements or public improvements. So there's the regular tax, which is according to the value of your property, right? So it's based on the assessed value of your property. And then there's the special assessment tax, which is, hey, we did some work. We did some work on the streets. There's new lights. There's new grass. There's new potholes. If you're in Newark, there's there's new a bunch of stuff, and you have to pay for it. So it's an additional tax that they impose on you. Okay, so there's the real estate tax, which is a general tax that you pay every year. And then there's the special assessment, which is based on improvements they add on to your bill. Okay. A judgment lien is very simple. Guys, I'm on page 67. If you have the physical book, it might be page 65. But judgment liens, it's pretty much a decision made by the court. The court says you owe money, right? So they made a decision. It's the judge's judgment. Judgment lien, court decision. Money, judgment. Okay, so these are self-explanatory. That's why I'm going right through them. A mortgage and a trustee lien, you guys already know. You borrowed money. There's a lien against the property. Mechanics lien, we just talked about, right? Is construction was done or the cost of labor or the material was not paid. So they can file a mechanics lien against you. And like I said, in contrast to other junior liens, the priority of a mechanics liens dates from the time when the work began or completed. Right? So this is the one that's retroactive. Okay? Guys, foreclosure, we pretty much already talked about foreclosure, so it's going to be like a quick overview. As you guys see, I try to integrate as much as I can so it flows, and then just a summary. But as far as foreclosure, there's the mortgage lien foreclosure, there's judicial foreclosure, non-judicial, and this simply means through court. Or bypass court. So if it's through court, then you're suing for foreclosure, right? You're suing to get your money back. If it's non-judicial, we bypass the court. That means we go straight to auction. We bypass the whole court proceeding, straight to auction. That's what it is. Here where it says in lien, this means, in lieu, I'm sorry, means instead. Okay? Instead. So when we're talking about deed in lieu of foreclosure, is you're telling the bank, hey bank, here's the deed, don't foreclose on me. Like, here, I give up, I'm out. That's what it is. Deed in lieu of foreclosure is an exchange. It's an agreement. Do not take me to court. Do not foreclose on me. Here's the house. Take the house, right? So we can do the same thing with cars. Like you call the bank and say, come get the car. So instead of repo, where they send somebody out, you can go take the car in. Totally up to you. Does it mean that you're off the hook with the monies? No, of course not, right? Unless you make a settlement agreement with the lender, but you might have to pay the difference of what they can sell it for and what you owed, okay? So the same thing happens in foreclosure. Vanessa's asking, does this happen often? Well, every lender should be giving this option to somebody that's about to go in foreclosure. So every lender should say, hey, debtor, you have a couple options. It's called Foreclosure Alternatives, okay? So we have a couple options. You either do a deed in lieu of foreclosure, or you attempt a loan modification, or there's a forbearance, which is putting the money for later, or we can do a short sale, where we attempt to sell the property, right? And it lessens the burden on you. So these are alternatives to foreclosure that should be presented. Does this happen often? No, a lot of people don't understand this, or they want to milk it till the end. They want to stay there for as long as they can and then eventually let the bank take it. So depends. Okay, all liens can be enforced by the sale. We already talked about this, and that sale is called foreclosure. Let's go straight into foreclosure processes. The ones you need to focus on are judicial and non-judicial. As I said, one has a court proceeding, the other one doesn't, just like a repo. In this one, let's go to non-judicial. This happens in states that are non-judicial states, meaning they don't have to go to court. Some states, like state of New Jersey, they are judicial, so you have to take me to court. Okay? In the non-judicial state, they accelerate the debt. That means they ask for the full amount due and owed and due immediately, just like a repo. It could happen in 90 to 180 days. They give you, after that, they give you a notice. They go to sale, and they can sue you for recovery of differences, like difference in money. So if you owed $300,000, bank was able to recover $150,000, you still owe $150,000. You don't have the house, but you still owe. Same with a car. In states like New Jersey, for instance, you default. They put you in court. They say, hey, you owe us $240,000, so we're going to sue you for $240,000. The least amount of time that this is going to take, because of due process, is 12 to 13 months. State of New Jersey is taking an average of 3 years, and I've seen as long as 10 years for somebody to lose the property. So it takes a long time, and then they can still come after the difference. All right, so that's the biggest difference between judicial and non-judicial. The word acceleration, as I was saying before, is, for instance, guys, you borrowed $300,000, your monthly payment is $1,000 every month, and you're behind 3 months. How much do you owe? You owe $3,000, right? Right? So are they going to sue you for $3,000? No. They're going to say, Your Honor, that's a lawsuit, Your Honor, there's a summons and complaint saying Your Honor, they're behind 3 months. It is my right to claim the full balance. Now, I know they're probably not going to pay the full balance, but I prefer to collect some in foreclosure than none over several years. You guys got it? So they accelerate the loan balance and all other sums due, like principal, interest, interest, fees, and whatever. They ask for it to be paid immediately through that court lawsuit. Okay? Now we have something called lis pendens. Guys, where do we file lawsuits? Who can tell me? Where do we file lawsuits? It's very simple. Anybody? Where do we file lawsuits? In a court. Thank you, Ramel. So, we have two different places that you need to remember. Lawsuits are filed in court, while mortgages and everything else are filed at Hall of Records. These are two separate and distinct entities. If I file a lawsuit here that affects the house, how will the general public know? Meaning, general public meaning, if I want to buy your house, how would I know that there's a lawsuit against the house? I won't. Unless, after filing the lawsuit, they bring a document called lis pendens and file on public records against the property. A lis pendens is not a lawsuit. It's a notice. It's letting potential buyers know, hey, buyer, if you intend to buy this house, just know that there's a lawsuit pending. You guys got it? So lis pendens limits your property, clouds your property by letting the world know that there's a lawsuit pending against it. Okay? So these are two separate entities. Hall of Record and lawsuit. Hall of Record and court. Two separate entities. So, what does lis pendens means? Lis means lawsuit, pendens means pending. So lawsuit pending. Lis pendens is a notice of lawsuit pending. It's not a lien in itself. Okay? It's simple notice letting the world know lawsuit is pending and it could affect the property. Any questions? Oh, simple. All right. Oh, Fraser got a question. There you go. In what way does it affect the property? Well, not the property itself, but the ability to sell the property does. See, let me ask you something. Would you buy a lawsuit, Fraser? Would you buy a lawsuit against you? No. So that's what it says. When you go buy this type of property, or any property that's in foreclosure, right? If you're aware of it, you know, well, I'm buying it for $300, but there's a lawsuit for $700. They can come and take the house away, and I'm screwed, right? So it's just a warning. It's just letting you know, hey, if you really want to buy this, just know that there's a lawsuit pending that could affect your ownership. Simple. Okay? So it doesn't affect it immediately, but it could. If there's an actual sale, so if it goes through the sale, one thing to remember is that the new owner receives the property title free and clear. Meaning, if there's only enough money to pay the first mortgage, that 1998 mortgage, right? If there's only enough money to pay that, the new owner is now responsible for the other debts. So the construction, the second mortgage, and so on, the new owner is now responsible. That gets all wiped out from the property. The previous owner still has the personal obligation to pay, but no longer has the property. You guys got it? If you buy a property at auction, it comes free and clear of any other liens except the one that you just paid for. You got it? And taxes. Taxes still got to get paid no matter what. Public records, Nina. So that's why you need to bring it to public records. So when you do a title search, you'll see the list pendants there along with first mortgage, second mortgage. So what we had here, when we go to foreclosure, we have to pull public records. And these are the public records, what we could see, right? So in 2005, they went through foreclosure. So if there's a foreclosure, there's a list pendants filed. So when we pull the records, we see, okay, there's a 1998 mortgage, there's a 2001 mortgage, there's a judgment against the property in 2003, and now, wait a minute, it's in court. And it's in court for non-payment of the 1998 mortgage, for instance. Okay? This is not the lien. It's not a lien, and it's not doesn't affect the property directly. It just gives the buyer a notice that says, hey, these might get paid, might not get paid, and you still have to deal with the lawsuit, which could be $300,000, right? $300,000, or it could be $1 million. It all depends on the type of loan they had. It depends on how the judge feels. It depends on a bunch of stuff. So, would you buy this property if it has a list pendants? That's what that's what it is. Zenaid says list pendants attached to property title. It attaches to property records. So yes, when you pull the title, when you do a title search, right? The title search shows everything in chronological order. So it shows who has priority after taxes. It shows who has priority. So that's why we went over this exercise to figure out who had priority in this scenario. So in the event of foreclosure, who gets paid first? Taxes. Who gets paid second? 1998. Who gets paid third if there's enough money? It'll be 2003 judgment, right? And who gets paid fourth will be 2001 mortgage if there's any money. So this all happens in the title search. If the title search did not show this, then technically how much money is owed here, right? You guys understand what I'm saying? It's only whatever's listed. But if there's a lawsuit pending, it's whatever the judge decides. It could be whatever's here, or it could be way more. You guys got it or no? Good? Cool. Does all debts transfer to the new owner? This is what we were just reading right here. The new owner receives the property free and clear. So if the lawsuit brings $200,000, so addressing Felix as well, if the lawsuit here brings $200,000, how many debts can we satisfy here with $200,000? How many? It's whatever the taxes is, and whatever's left over pays the 1998. So everything else gets wiped out from everything else. Sorry, hold on. Doesn't want to undo. No. All right, so everything else gets wiped out. That's what we were saying. So if there's no money, we paid the taxes. We paid a portion, as you guys can tell. We paid a portion of the 1998. I did this on purpose because it was a portion only. There was not enough money for everything. So everything gets wiped out from, oh, there you go. Everything gets wiped out. So there's not enough money for this. So we take it out. Against the property, because public records is against the property. and this did not get paid in full, we only had 200,000. We only had 200,000. So there's still a negative $100,000 to be paid. So the other ones just run as a loss totally? No. Guys, I was saying this before. It attaches to the property, but not to the property owner. The lien takes the property away. But whatever was wiped out right here, whatever was wiped out, the previous owner that owed the debt still owes the debt. The lien simply secures the collateral that says, hey, we can force the sale and try to recover as much as we can. But they're still responsible. The previous owner is still responsible for whatever was wiped out. It just now becomes unsecured debt. And that's why a lot of people go into bankruptcy right after to release the full debt. And then it becomes a loss for the bank. Yep. All right, and right here, deficiency judgment is where they can come after that difference that I just said, right? They recovered 200,000, but there's still 300,000 to be paid. They can sue you for the difference. Every state has something called a right of redemption. That means it's been 2 years, 3 years, whatever. Now you have the money, right? Now you have the money to pay the bill. You show up with the money right before the auction. You give them all the money in full. You redeem the property. Okay? So that's what it is. Right of redemption. Some states have like New Jersey's 10 days. Some states have a 1 year, and so on. If it's a non-judicial foreclosure, guys, I already told you there's no foreclosure suit. They just let you know, hey, in case you don't remember, you haven't paid the last 3 months of your mortgage. If you don't pay in full, your property will be scheduled for an auction in the next 90 days. That's pretty much what it is. They let you know you haven't paid. You haven't paid, but hey, you should do this. You haven't paid, and hey, now we're going to move forward. In the next 90 days, auction. Okay? So we completely bypass foreclosure. All right? Deed in lieu. Guys, we already talked about the deed in lieu is a deed in exchange for. I already covered this. Right? Is I give the bank the deed instead of them foreclosing on me. So it's amicable arrangement instead of friction in court. All right, so this one I already addressed as well. And with that, guys, we are done. You guys have any questions? Anything you'd like to address? It was a smooth chapter, right? The second one was smooth, right? Not that hard. The first one I know, chapter 4, ownership, tenants in severalty, tenants in common, all that stuff. I know that one can get complicated. Guys, hit me with questions. Anything you might have. No questions? All right, guys, if there's no questions, then, guys, I'll see you tomorrow. If there's any... Oh, hold on. Fallon has a question. Is that finger a question? Oh, about joint tenancy. Okay. There's a question. Cool. People already started logging out. Does it become fee simple or no? Okay, so fee simple means ownership. Tenancy in severalty, tenants in common, joint tenancy, and tenancy by the entirety, they are fee simple. Okay, it could be fee simple determinable as well. It's just now we talked first about okay, Jose, no problem. We talked. Thank you, by the way. We talked first about the different types of ownership structures, right? And then we talked about fee simple. Well, first we talked about fee simple and conditions of your title. There's a structure and there's conditions. Fee simple is free of conditions, and then it could be tenancy in severalty fee simple. It could be a tenancy in severalty determinable, meaning it's yours as long as. It's still fee simple, right? But with a condition, and it's one person. If it's two more people, so I sell, Fallon, I'm going to sell to you and to Amy, as long as you have, as long as you maintain the property as, I don't know, a parking lot. Okay, that's the condition. Keep it as a parking lot, right? It's tenants in common that own fee determinable. You guys got it? So the fee simple, fee determinable, life estate is pretty much the conditions of the ownership. Tenancy in severalty, tenancy in common, joint tenancy, and tenancy by the entirety is how you own it. So there's conditions, and then there's how you own it. Okay? Lee, is there a circumstance that debt will transfer to the new owner under? No. No. It would, in a short sale, you would have to agree. All right, so let me show this right here. In a short sale, you'd have to agree, maybe to facilitate, as a buyer, to facilitate. Can you agree to it? That's different. You can tell the bank, hey, to make this deal smoother, to make this happen, I will purchase the property and I'll pay for that debt right there. All right, just to make it happen, if you really, really want it. But can it be imposed on the new owner? No. Just taxes and special assessments. Debt? No. Okay? Any other questions? No? Ah, there you go, Nina. I was about to close the door and like, oh no, put the foot in. That's what she just did. Same as Fallon. Fallon just went like, put the finger up, like, wait. Nina froze. Okay, there you go. I was going to say you froze on the question. If you don't agree to debts during the short sale, does it extend the buying process? It does, because for a short sale to exist, every party must agree to release the lien. So the main lien holder, the one that's that has the let's say the first mortgage or whatever the foreclosing lien is, right? Can agree, can tell the second one, hey, we'll give you X amount of dollars. So in the short sale, there will be a credit for X amount of dollars on the second mortgage. Now there's a negotiation with the second and with the third. So for the property to transfer to the new owner, all parties must agree to take a cut, a short sale. Yeah. So could it extend? Absolutely. Okay. More? Once? Twice? So if you don't want to. If I don't want to what? If I don't want the debt, I don't have to pay. I just don't buy the house. That's what it is. As the short sale is by agreement. Like I said, the creditors must agree to release, the creditors, so the banks or the lien holders must agree to release the debt for a lesser amount. The buyer is not responsible for it, but the buyer might want it. The buyer might say, I'll pay the $3,000 on this mortgage, or $10,000 on this mortgage, or I'll pay the water, or I'll pay whatever, as a way to get this offer and process going faster. They have to agree to it, and they have to have money for it. But can they? Yeah. Do they have to? Nope. Okay. All right. All right. Anybody else? Going once, twice. Sold. I'll see you guys tomorrow. If anybody wants to join tonight's class, you can as well. It's going to be repeated next week anyway, but totally up to you. You can join as many classes as you want. All right, guys? Make sure you ask questions. Make sure you participate in the group chat. Make sure you use Quizlets, study, ask questions. Ask questions, ask questions. Very important. All right, guys? Have a good one. Bye-bye.